Alcohol and Controlled Substances Policy. Introduction and Policy Statement. The use of controlled substances and alcohol abuse has harmful effects on individuals' health and personal lives. Employees must take steps on their own to address these problems at home and among family members. The employer, however, must and will take the necessary steps to address illegal drug use and alcohol misuse which affect employment. Since the use of illegal drugs and the misuse of alcohol have also been demonstrated to impair essential job functions like coordination, judgment, concentration, and vision, to reduce operational efficiency and productivity, and to be a critical factor in workplace accidents, the employer has no choice but to do so. Because of these employment-related issues, state law authorizes the employer to issue a written policy covering all employees which, number 1, prohibits use of either alcohol or controlled substances in connection with employment, and number 2, requires testing under specified circumstances. In light of these safety and welfare concerns, the employer has adopted this policy to prohibit the use, possession, sale, and other distribution of controlled substances and alcohol in connection with employment, and to require its employees, as a condition of employment, to undergo controlled substances and alcohol testing when provided in this policy. The policy applies these requirements to circumstances in which employees are engaged in any work tasks, are present on employee or customer premises, or are operating or riding in any vehicle in the employer's service. Every employee and applicant is required to read, to acknowledge receipt of, and to abide by this policy as a condition of employment. This requirement does not constitute a guarantee of continued employment, and the employer continues to be an at-will employer. The employer's specific prohibitions and testing procedures are set forth in the pages that follow. After you've had a chance to review them and obtain answers to any questions you may have, you are asked to complete and sign the acknowledgement form at the end of this policy document. Prohibited Conduct. This policy prohibits the following conduct. Employees who have alcohol concentration of 0.04% or greater cannot report for or remain on duty, perform any work tasks, enter or remain on the premises of the employer or a customer, or operate or be transported in a vehicle in the service of the employer, except to be transported home or to a testing or rehabilitation facility. Employees cannot possess, transfer, sell, or receive alcohol, controlled substances, or drug paraphernalia while on duty, while performing any work tasks, while on the employer's or a customer's premises, or while operating or being transported in a vehicle used in the service of the employer. Employers cannot use alcohol while on duty, while performing any work tasks, while on the employer's or customer's premises, or while operating or being transported in any vehicle used in the service of the employer, or within the 4-hour period preceding such occasions. The only exceptions to these prohibitions of alcohol possessions and use allow employees to possess or consume alcohol during company-sponsored events for the employer's customers, during conventions at which sales staff are working and soliciting sales, during trade association activities, and during occasional company-sanctioned and sponsored functions. On such occasions, however, all employees, including drivers, are required to act responsibly and to exercise prudence in the amount of alcohol they consume. Employers who have used a controlled substance cannot report for or remain on duty, perform any work tasks, enter or remain on the employer's or the customer's premises, or operate or be transported in a vehicle in the service of the employer, except to be transported home or testing to a rehabilitation facility. Employees cannot refuse to submit to tests required under this policy, must cooperate and refrain from interfering with such tests, and if required to take a post-accident or reasonable suspicion alcohol test, cannot use alcohol or controlled substances for a period of up to 8 hours after notice that such a test must be taken and until the test has been performed. Tests required. Employees or applicants must submit to the following types of tests. Pre-employment testing. All applicants must undergo testing for controlled substances after a conditional offer of employment has been made, and the employer must receive a negative test result before the first time they are placed on duty, perform any work tasks, enter or remain on the employer's or customer premises, except to process an application, or operate or be transported in a vehicle in the service of the employer, except to be transported home or a testing site or rehabilitation facility. Post-accident testing. As soon as possible after any work-related vehicular or other accident involving serious personal injury or significant property damage, a serious moving violation or serious safety rule violation, the employer will administer alcohol and controlled substance test to each employee involved in the accident, irrespective of fault in connection with the accident. Employees subject to post-accident testing must remain readily available after the accident for testing, or they will be deemed to have refused to submit to testing. In addition, employees must refrain from using alcohol or controlled substances for a period of up to 8 hours after the accident until the post-accident test has been performed. Random testing. All employees performing safety-sensitive functions are subject to random testing for use of alcohol or controlled substances. Employees performing safety-sensitive functions specifically includes, but is not limited to, all employees who operate a vehicle in the service of the employer. Random tests will be unannounced and may occur at any time throughout the calendar year. Employees who are selected for random tests will be sent to the test site immediately upon selection and notification. Reasonable suspicion testing. The employer will conduct reasonable suspicion drug and/or alcohol tests. If one or more supervisors trained to detect suspected drug or alcohol use witness suspicious behavior on the part of the employee to be tested. The decision to engage in reasonable suspicion testing will be based upon specific, articulable observations about the employee's appearance, behavior, speech, body odors, or other objective symptoms of the use or withdrawal effects of use of alcohol or controlled substances. If a reasonable suspicion determination of alcohol or controlled substances use is made, the employee will not be allowed to perform any work duties until obtaining a negative result on a return-to-duty test. Return-to-duty testing. Once employees have engaged in contact prohibited by this policy, including testing positive for controlled substances or alcohol, or refusing to test, including by adulterating or substituting a urine specimen, or otherwise failing to cooperate with testing procedures, they are subject to alcohol or controlled substance testing before returning to work. In order to return to work, 24 hours must have elapsed since the positive test or other violation. Alcohol tests indicate an alcohol concentration of less than 0.02, and controlled substance tests must indicate a negative result for any use of controlled substances. Follow-up testing. Employees who have previously tested positive for but failed alcohol or controlled substances use, have refused to test, adulterated or substituted a urine specimen, or have otherwise failed to cooperate with testing procedures, have otherwise violated this policy, or have submitted a voluntary or other referral for assistance to resolve problems associated with alcohol misuse and/or of use of controlled substances, are subject to unannounced follow-up alcohol and/or controlled substances tests both during their evaluation and after their treatment. Periodic medical examination testing. Employees may be required to undergo drug and alcohol testing as part of their routine physical examinations required under law by the employer's policies. Procedures for testing. All testing procedures will be conducted in compliance with applicable federal and state laws and regulations, including specimen collection, laboratory testing, and communication of results. Laboratories utilized by the employer shall be federally and/or state certified and otherwise comply with applicable federal and state regulations and standards. Relevant portions of this testing procedure are summarized below. Controlled substance testing. When conducting controlled substance tests, the employer or its designated testing service provider will test for marijuana, cocaine, opiates, amphetamines, and psychosylidine, and may test for other controlled substances for which testing may be required or authorized under law. The employer has designated one or more collection sites to collect, store, and transport urine specimens. All urine specimens which produce a positive result will automatically undergo a confirmation test. When the laboratory completes testing, it will report the test results to the employer's medical review officer, the MRO, with an average of 3 working days of the laboratory's receipt of the specimen. The MRO will analyze the testing procedures and results, and if the MRO's attempts to contact the employee are unsuccessful, the MRO may verify the results without discussion with the employee. After verifying a positive result, the MRO communicates this result to the employer. Alcohol testing. Alcohol tests will be performed in compliance with applicable law, including Minnesota state law licensure and certification requirements for testing laboratories. Alcohol tests will be conducted in an area that affords privacy to employees, except in unusual circumstances which require tests to be performed in less private location, such as the scene of an outside accident. Confirmation tests will be conducted if required by federal and/or state requirements. If the results from the initial and confirmation tests differ, the confirmation test results will control. Limited access to results and testing records. The testing laboratories and personnel that the employers use to perform drug and alcohol tests will limit access to testing records and results as required by federal and state laws, except that the MRO and employer and insurance company personnel and agents with a need to know such information in the performance of their duties will have access to such records and results. Disclosure may also be made as otherwise permitted or required by law. Notification of test results. The employer will notify employees and applicants of negative and positive test results and their right to explain a positive test. Employer or applicants with positive test results can then submit any information they believe will serve to better explain that result or the reliability of that result within 3 working days of notification. Request of a confirmation retest or of the original sample within 5 working days of notification, or request a copy of the test result report. Notice of no expectation or privacy in connection with employment searches and investigations. The employer reserves the right to investigate and to interview employees in the course of implementing and enforcing this policy and other policies of the employer to require truthful answers to inquiries in connection with such investigations and interviews, to conduct searches of employees' persons, vehicles, workstations and locations, clothing, purses, briefcase, luggage, personal items, other possessions, documents, and any other articles within their possession or control while employers are on duty, an employer or customer property, or while operating or being transported in a motor vehicle used at that or any other time in the service of the employer, and to conduct the tests provided for in this policy. The employer may, in its sole discretion, seize any items which it deems to represent possible evidence of a violation of this policy or other employer policies or state or federal law. An employer's refusal to submit to such investigations, interviews, searches, and seizures, or to required tests may lead to disciplinary action up to and including discharge. Consequences of engaging in prohibited contact, testing positive for alcohol or controlled substances, receiving low-level alcohol test results, being under reasonable suspicion of alcohol use, and refusing to submit to alcohol or drug tests. Prohibited conduct, positive test results. If an applicant fails a controlled substance test, the employer will withdraw the offer of employment, even if the applicant's provisional employment has begun. Employees committing violations under Section 2 of this policy, including testing positive for controlled substances or receiving alcohol test results showing alcohol concentration of at least 0.04, will be removed from all work duties. After removal from work duty, such employees will not be allowed to return to work until at least 24 hours have passed and after passing a return-to-duty alcohol and or controlled substance test, and once back on duty will be required to pass unannounced follow-up alcohol and or controlled substance tests. See Section 3 of this policy. In addition to the preceding consequences, any other employee who violates this policy, tests positive for controlled substances, or shows alcohol concentrations of 0.04% or more will be subject to disciplinary action up to and including discharge, subject to the following limitation, and will not be paid for any period he or she is removed from duty as a consequence of such violation or positive test. The employer will discharge an employee based on the first positive drug or alcohol test for that employee. In the absence of a prior record of other disciplinary violations, only if 1. The employee has been given a chance to participate at the employee's expense in an appropriate rehabilitation program. 2. Has either refused to participate or has failed to successfully complete the program. For purposes of this provision, the employer will determine the appropriate counseling or rehabilitation program after consultation with an appropriate chemical use counselor or specifically trained physician. In addition, employees will not be allowed to return to duty until at least 1. At least 24 hours have passed. 2. The employee has passed a return-to-duty alcohol and or controlled substance test. 3. The employee has cooperated with and commenced any employer referrals and treatment rehabilitation recommendations to the employer's satisfaction. And 4. Appropriate discipline has been imposed. Employees will bear the cost of referral treatment or rehabilitation under this provision unless such services are routinely and without additional cost to the employer covered by existing insurance programs. Applicants who refuse to submit to or fail a pre-employment controlled substance test are not eligible for such referral, treatment, or rehabilitation assistance. Low-level alcohol test results. If an employee's alcohol test shows an alcohol concentration between 0.02 and 0.039%, the The employee shall be removed immediately from driving or any other safety-sensitive duty and placed on unpaid status for 24 hours. The employee will also be subject to additional disciplinary action if he or she has previously had low or high level positive alcohol test results or other drug or alcohol related policy violations, or if this result represents failure to adhere to a rehabilitation program. Suspected employee impairment. If the employer suspects an employee of controlled substance or alcohol use, the employee shall be removed immediately from work duties until a reasonable suspicion test is performed. Refusal to submit to alcohol or controlled substance testing. If an employee refuses to submit to testing, a first refusal will be treated in the same manner as a violation of this alcohol and controlled substance policy for purposes of follow-up actions and discipline. A second refusal will be treated as a resignation of employment. A refusal or alleged inability to produce a full urine, breath, or saliva sample for an alcohol or controlled substance test in the absence of a satisfactory and legitimate medical explanation confirmed by a licensed physician will be treated as a refusal to submit to testing under this policy. For purposes of follow-up action and discipline, the employer also reserves the right in such cases as its sole option to require that a lawful alternative alcohol drug testing method, including but not limited to breath or breathalyzer test, when appropriate, be immediately utilized as a testing procedure. A verified test result of specimen adulteration or substitution is considered a refusal to submit to testing under this policy for purposes of follow-up actions and discipline. Prescription drugs affecting safety. An employee who is taking any drug or medication that may affect his or her ability to work safely is responsible for informing his or her supervisor or other member of employee management before beginning work. An employee who is deemed to be incapable of working safely will not be permitted to work and will be subject to disciplinary action, including termination of employment if such notice has not been provided. Employer contact for questions about policy. Corporate safety has been designated by the employer to answer employee questions about this policy and the employer's drug and alcohol testing procedures. Release of test records. The employer will not release information regarding employee drug or alcohol tests, except as prescribed in Section 5. Upon written request, an employee can obtain copies of records regarding his or her violations, test discipline, and follow-up actions under this policy.